Hello everybody and welcome back. As we are bringing you this video today, part 4 on the Suzanne Morphew case, we have obviously now also received the news that Gabby Petito's body had been found. Our sincere condolences goes to her family. We shall try to follow the case as it progresses and will come on and talk about it once more is known about the circumstances surrounding her death, which means that we will have to wait for a cause of death to be released, and that may take a while. We truly hope that her family will remain strong through all of this and will receive the love and support they need and deserve. Of course, at this point, we also need to remind ourselves about Michael Monkey Vaughan, aged 5, Summer Wells, aged 5, and Orrin and Orson West, who are still missing, and essentially also Suzanne Morphew, who is also still technically missing. Regardless of whether any of these people are still alive or deceased, they need to be brought home and treated with dignity, love, and the respect they deserve. Okay, so on to part 4 of the Suzanne Morphew case. We are at this point not going to continue with the various witnesses called in the preliminary hearing, as the judge had already given his verdict, and dissecting every word now would be a moot point. So we are going to jump to the day of the hearing. At this point, I'm going to issue a warning. We are not going to give selective information. We are not going to skip certain things which were said on the last day because it does not fit with our narrative. We shall remain neutral as much as possible and shall endeavor to, at all times, treat the attorneys on the side of the defense and the prosecution, as well as the judge, the Moorman, and the Morphew families with respect. It is said that Barry Morphew had a number of family members and friends in the courtroom, I believe up to 10 people, and that some had flown in to attend the last day of the preliminary hearing. However, who they all were, we don't know. All we can tell you is that his daughters, Mallory and Macy, were seated in the second row, and his mother and sisters in the third row. We would guess that was due to social distancing in the courtroom. The prosecution went first. Attorney Edwards was talking about probable cause, citing cases in other states like Rhode Island, Alabama, and Florida. He also spoke about whether Barry should be allowed bond or not. Deputy District Attorney Lindsay was up next and stated that Suzanne started her path to getting killed on May the 6th because of her "I am done, let's do it civilly" text. She stated that it was a domestic violence homicide and or intimate partner homicide. On May 8th, Suzanne listed grievances, and on May 9th, she texted her sister saying that Barry was emotionally and physically abusive. Next, she phoned Barry when she gave him these grievances as the reason why she does not want to be in the marriage any longer. So we shall stop here for a moment. We found Deputy District Attorney Lindsay's rhetoric superfluous and unnecessarily dramatic, with very little except the existing records of phone calls and text presented as fact or being fact-based. Lindsay refers to a domestic violence homicide, but going back over the evidence provided at the preliminary hearing, there is no proof of prior domestic or regular domestic violence. And I just want to remind you that Macy's boyfriend, Miles, actually told police that he had never seen or heard of physical violence in the home. Until Barry was arrested, no one had come forward in reporting prior violence either, and as far as we know, Suzanne had never presented herself to friends, family, police, or a medical facility with extensive bruising or broken bones. The only indication that there may have been some sort of physical altercation is something which allegedly came from Barry himself when he said that he accidentally clipped Suzanne's nose once. The only other reports came from Suzanne herself via text to her friend and sister. At this point, we then have to look at the situation Suzanne found herself in and the psychology behind it. The fact that Suzanne told her sister that Barry was emotionally and physically abusive and told her friend that she suspected Barry of having an affair is classic deflection from someone involved in an extramarital affair. We cannot say that there were no abuse. We were not there. All we are saying is that there is no substantial evidence of it, and that Suzanne's word alone cannot be seen as evidence under the circumstances. Referring to a number of papers written on the subject of spouses or partners involved in extramarital affairs or affairs, there are certain behavioral patterns, and those need to be taken into account when it comes to Suzanne's texts and communications with her friends and sister. These behavioral patterns include the following. When a partner is cheating, they will likely display signs such as hiding their phones, staying out later, and making drastic changes to their appearance. Here we can take into account the spy pen Suzanne bought, the separate secret WhatsApp account, etc., etc. Suzanne may not have made a drastic change to her appearance, but she did take up cycling since she started the affair with Libler. As an affair progresses, the party having an affair will attempt to manipulate their partner into believing that they are not cheating, but will blame their partner for the problems in the relationship, or make their partner out to be the cheater. We see this clearly here with Suzanne's list of grievances, and again with her telling Sheila she is suspecting Barry of having an affair, and ultimately with the spy pen she then obtains. This all while, in fact, she was the one having the affair. And I'm not victim blaming here. This is just fact. It was stated in court that she had a 2-year affair and that there was no evidence of Barry having an affair. So I'm not thumb sucking here. I'm taking it straight from evidence. When a partner suddenly and out of the blue accuses the other one of cheating, it is called projecting. It is a defense mechanism when they are in fact not prepared to deal with reality. It also puts the non-cheating partner on the defensive and distracts attention from their own actions. They will also try to confuse their partner. For example, say things like, "You are confused," when you point out a discrepancy in a story. Or they will say you heard them wrong, or that their partner remembered something wrong. They will pick fights and highlight their partner's shortcomings. And again, we can refer to Suzanne's list of grievances. Also, that she allegedly told her friend that Barry was boring and not intellectually challenging. Now, I know those are not her exact words, but she said something of the sort, and quite frankly, this video is going to be too long and too time consuming for me to actually go and look for the exact words. Anyway, They will also claim that the non-cheating partner is jealous and irrational. And we saw Suzanne doing this in so many words. They will accuse their partner of invading their privacy. We heard Suzanne describe Barry as being controlling, which could mean that she was becoming irritable when he entered her private space. But she described it as controlling instead of as invading her privacy. The cheating partner may even become possessive and regularly accuse the non-cheating partner of flirting with others or betraying them. And we have seen this, as I said. Also, concerning the list of grievances she shared with her sister and then Barry, we must remember that her grievances were against Barry, his actions and his handling of their marriage. And we know that nowhere did she actually admit to an affair or being in love with someone else. And we know that because her friend Sheila said that Suzanne did not tell her or anyone about the affair. Libler himself said that Barry did not know about the affair. And according to law enforcement, Barry said that he did not know about it when they told him what they found. It is obvious, though, once we go through the arrest affidavit, which I did last night, that Barry had his suspicions and he told Suzanne and Holly about it. Deputy District Attorney went on to state that the timeline of events between the 6th and the 9th of May proves that Suzanne wanted out, but Barry did not want a divorce. Again, let's put the brakes on. It is not uncommon for one partner to want a divorce and the other one not, but it is not proof of murder. Statistically, a murder will take place during or after divorce proceedings, or when one partner is in the process of actively leaving. Suzanne and Barry did not seem to be at that point yet. As a matter of fact, the evidence proves otherwise. Evidence like on the 7th, Suzanne still texts Barry that she made veggie stew for dinner. On the 7th, Suzanne texts Libler about how great the last few days had been. On the 8th, Suzanne sends a picture of Barry waiting for pizza to the girls. On the 9th, she texts Libler stating that she had a fine night. On the 9th, there is a back and forth between Suzanne and Barry, meeting up to go for a hike, etc., etc. Deputy DA Lindsay follows this statement up by saying that Suzanne let her guard down and that May 9th was the day of reckoning for Barry. In legal terms, this is an assumption and not a statement of fact. District Attorney Lindsay also stated that the bike helmet was staged by Barry. Now, two things stand out to us at this point. One, Barry admitted to being in the area after following elk. Why would he even admit to being in the area if he knew that it could implicate him? Particularly in light of the fact that the tire prints found near the helmet does not match his or Suzanne's vehicles. District Attorney Lindsay then talks about the fireplace evidence. Now, Barry admitted that they burned papers, but so far we have not heard any evidence that the stuff found was burned before or after Suzanne's disappearance. Then the Deputy DA talks about the trash runs. From evidence, we find the words used rather misleading. If anything, one could refer to this as trash dumps and not trash runs, in line with the fact that Barry dumped items at places that he went to. For example, McDonald's, where he washed his front window, the hotel where he went to stay at, and it was not as if he drove from one trash can to another in obscure areas, putting things in random bins and dumpsters. No, instead, he dumped stuff at places where he went to anyway. So, trash runs gives you the impression that he drove from one trash bin or one dumpster to another with the sole purpose of dumping evidence, which is not what we get from the evidence presented. I'm not 100% sure about this, but from what I could deduce, Barry was only caught on camera 3 times putting things into bins. He agrees to dumping some stuff, and from what I can deduce, he denies dumping anything at least one of these incidences. Deputy DA Lindsay then briefly talks about the tranquilizer evidence. She mentions that a biologist said if Suzanne was tranquilized, she would have hypoxia and snore. Now, I went and looked it up. Hypoxia is described as when blood oxygen levels are too low and your body may not function properly. Hypoxia can cause mild symptoms like headaches and shortness of breath. In severe cases, it can interfere with heart and brain function. To date, we have only heard of the tranquilizer cap being found and the tranquilizer gun actually not working. So we can only assume that the prosecution is suggesting that Barry stabbed or injected Suzanne with the tranquilizer material or dart. Unfortunately, because there is no body, it cannot be proved that Suzanne was tranquilized. Now, it's a possibility, but there is no body that can be autopsied or tested for chemical residue, and therefore, at this point, this is just a supposition or a guess. Anyway, next up was the defense. According to the defense, May 6 was of no consequence to whatever happened since and or Suzanne's disappearance. They used the same argument as I have already highlighted, namely that May 8th seemed to have been a fine night. They went to town, looked at real estate, etc., etc. Barry also did not respond with violence to the "I am done" text on the 6th. There is no evidence of prior domestic violence, nor that he ever threatened her, and thus the prosecution is speculating and not giving evidence in this regard. The defense alleges that there is no proof of opportunity to kill and or dispose of Suzanne. The defense also calls the state out on them changing their story from Barry hunting Suzanne down to carrying a syringe instead of a gun. The defense then refers to the DNA related to and matching with 3 unsolved sexual assaults. For us, this is perhaps the most crucial piece of evidence in Barry's favor, and absolutely essential that this perpetrator be found, as not only may he have crucial information on the Suzanne Morphew case, but this person is obviously a sexual deviant who preys on women and who still presents a threat to women, even if he is not guilty of Suzanne's murder and disappearance. The defense mentions Jeb Libner not coming forward. Although this speaks to the character of the man, law enforcement had already ruled him out as a suspect, and therefore this is, in my opinion, of little consequence, except maybe to reiterate that Barry did not know about him until he was informed of the affair by law enforcement. Then the defense addresses the Facebook incident. when 23 people, 20 men and 3 women, were friended from Suzanne's Facebook page. Now, the original story was that someone, likely not Suzanne, befriended these people at midnight on the 9th. In other words, shortly before or during or after her disappearance. However, from evidence presented, this happened between 8 and 9 p.m. on the 8th, and therefore the defense points out that although the state wishes to present it as evidence that Barry used the Facebook account to create an alibi, it does not hold water, because we do know that Suzanne was in communication from her very own phone with a number of family members, etc., on the 8th. And we also know that she was still alive on May the 9th, at least for most of the day. Defense also points out that the state made a miscalculation with regards to the missing 19 miles, as 18 of those can be accounted for by Barry visiting Salida Stove and Spa. And although there's a huge discrepancy as to how late or when on Saturday he visited the spa, it is still a fact, and it has been said that he had been seen there, and there are also texts from Suzanne reminding him to pick things up from there. Then the defense points out that Barry's DNA was not found on Mallory's sheets or the tranquilizer cap. Now, interestingly, I was under the impression, because the things were found in the washer dryer, that there was perhaps no DNA found on the sheets or on the cap. However, as I said, I read the arrest affidavit last night, and something very interesting I found was that Suzanne's DNA was on the tranquilizer cap, and that there was somebody else's DNA on the tranquilizer cap. And my question would be, why is this other person's name redacted from the arrest affidavit? Because if the prosecution alleges that Suzanne was tranquilized before whatever happened, then it is absolutely essential to know who the other person was whose DNA was found on the tranquilizer cap. It is also said in the arrest affidavit that Barry's DNA was not found on the tranquilizer cap, and that too is very interesting. The defense then reiterates that the chlorine smell in the hotel room was explained by the room's proximity to the hotel pool, and we've been through that again. The defense then alleges that the half-empty coffee cup most likely proves that Suzanne went about or finished her morning routine. As we were told, Barry does not drink coffee. It is the opinion of the defense that the state's case is based on supposition and not facts, and asks the court to end it. Finally, it is the judge's turn. The first thing the judge says is that the case cannot be bound over because a body was found, but instead that it was a probable cause hearing based on her disappearance and the prosecution's stance that she was murdered by her husband. The judge then stated that he could find probable cause without a body, which is absolutely 100% correct. And there are numerous cases of murder trials going ahead without a body. However, we do want to stop here and explain. Another channel, and I'm not going to name names, made a big mistake here. And one, I think, is a mistake which has to be rectified in order to ensure a fair trial. By saying the judge found probable cause The judge is not saying that Barry is guilty of the murder charge. Instead, what he is saying is that the state presented enough probable or likely evidence to warrant a trial. So the judge's ruling and statement and action is 100% correct and 100% within the confines of the law, as there is indeed enough evidence that something nefarious could have or may have occurred. In my humble opinion, the state did not present any solid evidence that Barry was responsible for Suzanne's death, and neither did the defense provide solid evidence that he did not. The judge's statement that there could still be a reasonable belief that the defendant, Barry, may have committed a crime is thus a balanced and true statement. The judge also explains this statement that, as such, he does see probable cause for a first-degree murder and tampering with a deceased body, which is also fair to say, because the mere fact that Suzanne's body had not been found would have anyone surmise that if she is deceased and Barry did do it, he must have done something to her body or with her body, because it hasn't been found. In the judge's opinion, Suzanne having an affair could have given Barry motive. He actually mentions hurt, anger, desperation, hurting someone who hurt him. However, it is here where we sort of feel that the judge is grasping a little, as there's no evidence that Barry knew about Suzanne's affair. He may have suspected that she was involved with someone else, but there's nothing to prove that he knew it for a fact. The judge then carried on saying that the "I'm done" text meant dissolution of the marriage. A text to Libler said, "The next few days will be rough," but again, it appeared not to have been as they went to town, looked at properties. Suzanne herself said they had a nice evening, etc., etc. The judge also points out the damaged door frame. However, in our opinion, this is also circumstantial evidence, as there's no proof of when it happened or who caused it. There was no blood or any DNA or any evidence of any kind on the door frame to suggest that Barry may have caused the damage, or for that matter, when the damage was caused, had it been him who caused it. I personally nearly knocked a door frame right out trying to get a bed into a room when we moved the last time. According to the judge, Suzanne said she did not feel safe and said Barry is unstable. According to the judge, this shows that Barry was capable of harming her. I personally feel that this is conjecture and hearsay, and that there's a possibility that this was deflection and projection and blaming, when in fact she was the one having an affair. They were married 26 years, and if there was evidence of domestic abuse, someone, somewhere, would have known. The judge then adds that the truck door opening and closing before 4 a.m. is relevant evidence. The judge confirms that Barry being in the area where the helmet was found was relevant. I would have liked to ask the judge to explain why none of the tire tracks then did not match Barry's truck, as the helmet was found a couple of meters away from the road. But okay, let's carry on. The judge also questions why Barry left his wife alone that Sunday and ended up sitting in a hotel room for nearly 5 hours. Based on all of this, the judge found in favor of the state or prosecution on counts 1 and 2, first-degree murder and tampering with a deceased body. However, and this is the part another famous YouTuber in the true crime genre left out, perhaps because it does not suit his narrative, the judge now has to consider bond, and right from the outset, he says that there are still three possibilities, and I quote, 1. Barry killed Suzanne. 2. She voluntarily disappeared. Or 3. Someone else killed her. Based on this, the judge finds that the prosecution did not provide enough evidence for first-degree murder and did not meet the burden of proof, evident, presumption, great, and therefore the court is obliged to set bond. Now, at this point, I would also like to refer you to Scott Reich's channel, Crime Talk, as he called it long before the judge gave his verdict. Now, I don't always agree with Scott Reich, but I do always watch Crime Talk, and I have been keeping score just in case he's listening. And I must say that at this point, he has scored 10 out of 10 as far as it gets to predicting the outcome of a court case. So if you guys want to hear more about burden of proof, evident, presumption, great, I recommend that you go to Scott's channel, Crime Talk, and I'll put a link in the description box below, and listen to a real attorney explain this. So once again, in my opinion, and more importantly, in the opinion of a real defense attorney, Scott from Crime Talk, the judge was 100% on point and 100% acting within the law. The DA immediately responds by asking for a $10 million bond and alleges that they believe Barry is a flight risk as he no longer has ties to the community in Colorado. According to the DA, they fear for witness safety and they believe that Barry has $3 million since the sale of his home and business. The DA states that there is a risk that Barry will flee and feels that he should be monitored. The judge then asks whether Barry has a criminal history, and Iris Eaton points out that there was a disorderly conduct case after a fight between Barry and another worker, but that the charges against both were dismissed, and he thus does not have a criminal record. Eaton points out that Barry is 54 years old, has a supportive family, 2 daughters, and friends in the courtroom, and that he intends to live near his 2 daughters who do live in Colorado. She states that Barry is okay with any protection order the court puts on him and that he does not have $3 million. She also states that a $10 million bond will be as good as no bond. She then reiterates that an amount of $50,000 to $200,000 would be a typical bond for a Class 1 felony case, and therefore the defense is asking for a $50,000 bond. Eaton says Barry has been made a public spectacle of, wrongly defamed, and sustained a great financial loss, and that it would be hard for him to work and earn money now. His attorney suggests that the court takes away his passport, give him a constitutional bond, and allow him to go home to his daughters. Eaton also asks at this point whether Barry can live in Gunnison, and the judge said no, he must remain in Chaffee County, but that although he has been charged, he should be treated as innocent, at least until found guilty by a court of law. The judge agrees that $10 million is too high, but that 50,000 is also too low and gives Barry a bond of $500,000 cash only. The judge also hands down protection orders for the Moorman family: Brad Oswald, Holly Wilson, Sheila Oliver, Cassidy Cordova, Morgan Gentile, Jean and Martine Ritter, and Jeff Libler. Barry may not have any written contact, no electronic contact, or ask anyone to contact them. Barry must surrender his passport, appear in person at every hearing, and wear an ankle monitor. Then they get to the arrest affidavit. Drew Nielsen says the arrest affidavit reads like a tabloid and that it was written to try the case in the media and to taint the jury pool, and that they do not want the arrest affidavit released. The judge finds no valid reason to suppress the affidavit, etc., etc. Now, I read the arrest affidavit and am inclined to agree with Attorney Nielsen that it does read a bit like an article written for a tabloid. And I also agree with her that the way the case has been discussed in the media, and in particular on social media, and the way certain elements and parties are talking about it, adding their own dramatic and scaremongering tactics to hype up their own popularity, will certainly taint a jury pool. I also feel, again, like Scott of Crime Talk, that the courts are constitutionally bound to be transparent, unbiased, and available to public scrutiny, and that the judge had no choice but to release the arrest affidavit at this point. The court had already redacted information which is not admissible in court, and therefore they have done what they could to preserve the integrity of the case. The defense then asked for a date for the trial to be set. Deputy DA Lindsay says that the trial will or should last approximately 4 weeks, and the defense asks for commencement in May 2022. The judge then agrees to a trial from May the 3rd until June the 1st next year, and Barry enters a plea of not guilty. Eaton then tells the judge that the prosecutors with the DA's office have participated in interviews, podcasts, and fueling the media frenzy, and asks for a gag order on them. The judge decided not to rule on it at that time and says that if there is a violation, it will be a self-inflicted wound, and he then sets a motion hearing for the 9th of November at 1:30 until 3:30 p.m. for the discovery violation and motion of violation of the court order to limit pre-trial publicity. Here again, compared to other cases I've watched over the years, I feel that Eaton was 100% correct. I'm yet to see a district attorney discussing a trial while it is still ongoing in the media, and in particular on podcast or YouTube. I find it unprofessional and a clear attempt to gain and attract attention to themselves, possibly for career advancement. Once a case had been completed, it would be a different matter. But in light of the fact that a jury still needs to be selected, it is downright irresponsible. I also think it's rather embarrassing for the prosecution that the defense even had to enter this motion. Now, I watched the short video of Barry leaving the prison with his daughters today, and just to shortly give you my general opinion, regardless of the scaremongering going on, I do not believe that Barry will run or abscond. What other YouTubers also did not mention was that one of the daughters, I think Mallory, left the courtroom with a private investigator during the court proceedings. I believe this is an investigator hired by Barry's lawyers and family. Barry had to surrender his passport, and unlike the movies, It is not that easy to obtain a false passport, particularly not in a place like Chaffee County. I also do not think any of the witnesses have anything to fear from Barry. He has known for months now who the witnesses will potentially be, and there is no evidence that he made any attempt to harm them. Of course, I do not know Barry, but he appears to me as someone who could be more mouth or more show than guts. I've listened to him speak twice and read the arrest affidavit, and with all due respect, he does not come across as particularly sharp, clever, or organized. So, my dear listeners and viewers, that's all I have for you today, and I think for the time being, this will conclude our series on Suzanne Morphew and the Morphew case. I do hope, however, to see you back on here when we bring you the next mystery. So until then, take good care of yourselves. Bye.